Welcome to the Capital Forum's interview series. My name is David Blotner, and we are delighted to have Jessica Delbaum here with us today. Jessica is a New York-based partner in Shearman & Sterling's Global Antitrust Group. Her practice focuses on defending multinational companies' mergers and acquisitions before both Federal Trade Commission and the Antitrust Division. She started her career at DOJ's Antitrust Division as an Attorney General's Honors Program attorney. Jessica, thank you for coming here today.
Thank you very much, David. Pleasure to be here.
I wanted to talk with you about something interesting that happened this past year that we don't always see in merger deals. Usually when a merger deal gets announced, the companies downplay any antitrust risks that the deal may have. With the Men's Warehouse Joseph A. Banks deal, when that deal started, one of the parties, Men's Warehouse, raised significant concerns that there may be antitrust risks to a merger with Joseph A. Banks. So when a company comes out publicly and talks about a deal creating antitrust risk, what's your first thought as far as what kind of message that sends?
My first thought is it's probably a hostile transaction. The party that's coming out there saying that isn't interested in doing the transaction, but also hasn't necessarily thought about a few steps down the line. In most instances, to the extent a transaction that started out hostilely actually gets completed, it tends to turn friendly at some point. The parties meet over money generally. So I think starting off with a statement like that, where down the line it actually may turn into a friendly transaction that, in this instance, Men's Warehouse wants to close, they may not have thought about that initially when they're making those statements.
So when they make a statement like that, as an attorney for one of the companies, what are the things that you're thinking about in terms of what the consequences may be down the road in case the deal does turn friendly?
I'm thinking even if there was a possibility that an agency might have not noticed that there was an overlap here that they might want to investigate further, that if one of the parties to the transaction is saying, I think there could be a long, for example, FTC review with it, that the FTC is going to take a close look. Would that have happened regardless? Very well could have, but I think by saying something like the FTC is going to take a long look at it, you are ensuring that they will indeed take a very close look at the transaction. Because the FTC and the DOJ, they're monitoring what companies are saying in the press, what they're saying to investors.
So if an executive has come out and publicly said that there's antitrust risk to a deal, he's made that statement. That statement is now out there. What kind of problems does that create?
I think it creates challenges that to think about strategically of what's going to happen down the line. Just because a company CEO executive says there could be an antitrust review with this, don't know what the result will be, doesn't necessarily mean that there actually are any substantive issues. Don't know what formed the basis of him saying that, whether it was just sort of reading the press and saying, oh, the Obama administration is taking an aggressive look at antitrust these days, and so deals in the same space are getting closer scrutiny. So it may end up not meaning anything, but as I said, I think it will mean that the agency is taking a close look and that the executive can expect to be asked about their views of the transaction.
Okay. In your experience, if there's a hostile tender offer, the way there was with Joseph A. Banks and Men's Warehouse, when they respond to that publicly and say what their position is, the executives have thought about what they're going to say, right? I mean, they've been counseled about sort of what they should be saying and taken a particular position.
Unclear, frankly,
right.
Whether that's the case or not. It could be, it might not be.
Right. Would you want them talking about antitrust risk in terms of trying to sort of explain why they're not interested in doing a deal? Is that something you would advise a client to discuss publicly?
So if we had representing a client that was the subject of a hostile tender offer, would generally think that they want to take a neutral stance with respect to antitrust issues, both with the public and with the agencies, frankly. Because, as I said in the beginning, you don't know what's going to happen down the line. That's not to say that they shouldn't be factually accurate, but not to try to advocate one way or another.
Okay. So if an executive does go out there and make a statement like that, are there likely going to be documents that the agencies are going to be able to get that will support the executive statement?
I don't know what documents there would or wouldn't be. There tend to be documents, for example, that would go in with the filing, and even though the subject of an all-cash tender offer doesn't actually have to make the HSR filing to start the waiting period, they are obligated to make the HSR filing, so eventually they would submit their 4C, so-called 4C and D documents, which would talk about documents prepared by or for officers or directors that analyze the transaction with respect to, let's say, competition. So to the extent there are documents, those would go in. To the extent there were documents that reflected legal advice or legal strategy, those would be withheld as privileged, even if they were otherwise responsive.
And if an executive has gone out and publicly talked about antitrust risk, are you concerned that the executive may have waived the privilege?
I think it is a provocative question. I wouldn't be concerned that they had actually waived the privilege simply by saying something like, think that this transaction will get a close look by the FTC and there could be issues. I think statements such as that wouldn't waive the privilege. They're not revealing the substance of communications with counsel, and a simple conclusory statement like that, I think, would not waive the privilege.
Okay. Do you think it's going to attract the agency's attention, though, to trying to obtain privileged documents that they otherwise might not have been that interested in?
I actually don't think it would cause them to seek and try and argue that they had waived privilege. I mean, in fact, recently in the US Air American Airlines transaction, the agency took the opposite position. The defendants in that transaction made a motion to the court saying that the government, when they were seeking from the government past their analyses of past airline mergers, saying by issuing closing statements, by writing an article, having the economics group write an article about these past transactions, the agencies waived privilege. And the DOJ said, no, we absolutely have not. And the court in the special masters came down and sided with the government, saying that these conclusory statements hadn't waived privilege. And I think there are other instances that are similar. So I don't know that the agency would seek to say, you've waived by making this general statement out there. Would they still ask the factual predicates? Absolutely. But I think they would do that regardless of a statement that an executive had made.
Okay. And as far as trying to prepare an executive who's gone out and talked publicly about the antitrust risks, that's certainly going to be fair game for asking him the basis for his statement, right? I mean, if he's being deposed by one of the agencies, if they do an investigation, he's going to get asked about that statement.
He may or may not, and to the extent that he gets asked about it, and that his public statement was based on advice of counsel, communications with counsel, I would advise him, whether it was under oath or just in an agency meeting, not to answer to the extent it reflects privilege. Again, to the extent the agency wants to ask underlying factual questions, who do you think your competitors are? What do you think customer reactions are going to be? That certainly isn't privileged, but to the extent making a general statement out there was informed by communications with counsel and responding to that would reveal those, I would advise him not to answer so that he doesn't waive.
Right. Let me go back to one other thing that sometimes can happen in these hostile situations. The parties may come into the agency actually and try and persuade the agency that there's a problem in order to convince the agency not to approve the deal. What happens there if you've gone in and made a presentation and tried to explain why you think there's a problem on behalf of a client, and then the deal turns friendly? what happens?
There's the potential that you could have a credibility issue. Again, I think it would depend on the facts of the circumstance and what was said to the agency. If part of it was, this is preliminary, we haven't gone out there and talked to folks, but, you might want to investigate further, bump, bump, and bump. And then you later came back and said, well, we've actually done some more internal looking and talking to people, and we think blah, 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 then I think it's less of an issue. But to the extent you said, we've got lots of customers out there who are very concerned, and they view, only us and Joseph A. Banks as their alternatives, and there's, lots of intense competition between us, and in fact, look at all these documents that say it, and then all of a sudden you say, but wait, we actually have this whole host, of boxes B and C that talk about competition with other retailers, and you need to consider those once it becomes friendly. I think you have a little bit of a credibility issue, but, the facts will be what the facts are.
Jessica, I want to thank you very much for talking with us today.